President, please be seated. The court is now in session. As scheduled, today the chamber continues to hear testimony of the witness, Suf Rumli. And we also have a reserve witness, that is to TCW 996. In relation to the Piantmo Dam worksite. However, late yesterday afternoon, Defense Counsel for Nujir, that is Counsel Copper, made an observation in relation to the conflict of interest of the duty counsel and witness, that such an issue may arise in this particular instance. The chamber actually deliberated on this matter since yesterday, and so far we haven't reached a conclusion and made a ruling yet. And secondly, out of the 3 UT councils, none is available to replace Council Dutch Paris, that is based on the confirmation by Visu. And arising from this issue, there was another issue in relation to the disclosure of documents from cases 003 and 004 into case 002, and that raised some concerns in relation to the procedural matters. For that reason, the chamber cannot hear the testimony of the current witness, that is Suf Rumli. Likewise, the hearing of witness through TCW 996, who is in a similar situation comparing to witness Suf Rumli, as he has the same duty counsel, that is Counsel Dutch Paris, and which is the core of the deliberation of the bench, as there could be consequences from this matter. This is compounded with the disclosure of documents by the international co-prosecutor from cases 03 and 04, and that attracted submissions from other parties. So, for that reason, the chamber cannot hear the testimony of the witness through TCW 996 tomorrow. For that reason, the hearing of the 2 witnesses, that is Suf Rumli and through TCW 996, will be deferred to a later date, that is after the Pchumban break. The Chamber will take active consultation with the Visu concerning their availability after the Phnom Festival. So this is to inform the parties that the Chamber will not hear the testimony of witness Suhrum Lee and to TCW 996. And court officer, please, in collaboration with Visu, make necessary transportation arrangement to send the two witnesses back to their residence. President, I noticed that the defense counsel for Kisampon wants to take a floor. And in fact, the Chamber has not yet made a ruling in regards to the submission by Nunchi's defense. Kisampon's counsel, if you have something on your mind, please take the floor.
Excusez-moi, Monsieur le Président, je n'avais pas compris si vous souhaitiez d'abord aborder la question de la présence de Nusha à l'audience pour ensuite évoquer, faire ma requête. Ah.
Since we will not hear testimony of witnesses, then the Chamber will give you the floor to make your points, and I don't think it will take that much time. Is there any interpretation issue, as the English channel didn't go through before? President, through the Chamber's view, there will be no hearing of testimonies today, and we will not make a ruling yet on Nunchi's submission. However, we will give the floor to the parties, in particular to the defense teams, who may take the floor briefly in response to the issues, so that the Chamber will have the ground to deliberate on these issues. If you have any points related to these issues, you may take the floor, Counsel.
Thank you, Mr. President. I'm reacting to the observations already made a few days ago in relation to the necessary preparation of the defense teams for the final submissions. Yesterday, at the end of the afternoon, we received new elements from the Supreme Court because they told us that the final submissions are set from 16 to 18 November. Those are for the final submissions, but still there is the possibility that witnesses will be heard before the Supreme Court before that date. So under these conditions, I'd like to repeat my request that was considered premature a few days ago. That is to say, having the possibility of not having any hearings during the time when we will prepare our final submissions. Ideally speaking, we were asking for 5 weeks of preparation before these final submissions, with, of course, this unknown factor of possibly hearing witnesses. But in any case, this means that we are requesting the trial chamber to not program after Phnom Penh new witnesses, and that the chamber wait until the end of the final submissions, that is to say after the 18th of November, to continue with the hearing of witnesses, in this case is 002/02. For the moment, this is all I can say based on the elements that I have received. It's clear that this preparation time is not going to be a vacation. It's going to be a very important load of work that we're going to have to deal with because the stakes are very high. So all parties, including the Chamber, may benefit from this time to work on the other elements that are important in this case, 002/02, which might allow us to resume with the hearings later on a more fluid basis. So our request is that there be no hearings programmed after Pumben and before 18 November. That is to say, when we will be done with our final submissions before the Supreme Court. Thank you.
President, any other observations to be made by other parties? Councillor Copper, do you have the floor?
Thank you, Mr. President. Good morning, Your Honours. We concur with the request of the QSAPAN team, but with the exception that because also of the relevance of the appeal of the testimony for the appeal of witness 996, we would request that this particular witness, who is now not coming tomorrow, would at some point be heard before those hearings. I don't think the QSAPAN team will be very happy, but for us it's very important that 996 will be heard before the hearings in the Supreme Court chamber. So, but we concur with the period of time except for one particular witness.
And the International Co-Prosecutor, do you have the floor?
Yes, good afternoon. Good morning, Your Honors and Counsel. When this matter was raised previously, we did indicate that it was premature as a schedule had not been given, but now we have an indication of dates and the time that the Supreme Court will devote to the oral hearings, which are 3 days. We certainly think it's important for all parties to be prepared, but the briefing on the appeal has taken place some time ago. I think our response was filed in March or April of this year. It's our view that we also would appreciate some time to prepare, 1 week at least, to prepare for the appeal hearings. Assuming that there is no witness called by the Supreme Court chamber, and I'm not sure whether there will be or not, and I'm not sure that that would affect what I'm about to say, but if the chamber did not have any witnesses from the 8th of, I'm looking at the calendar for November, if the hearings on this trial concluded at least by the 12th of, the 5th of November, then all parties would have 11 days to prepare for the appeal hearings, not counting the current period where apparently we will be sitting dark because of the problems with witnesses that Your Honors just mentioned. We do think that 7 weeks would be excessive, and that in effect is what the defense is asking for if we stop, as I understand it now, hearing witnesses, or even if we stop after the holiday, 6 weeks would be excessive. Considering that with 3 days of hearings, I presume the time will be divided equitably by the Supreme Court so that the defense teams together will have about a day and a half to present their oral arguments, so about less than a day for each. We think a week or 11 days would be sufficient time. It's up to Your Honors to decide that, but at least we suggest that 5 weeks would be an excessive amount of time to prepare, given all the other demands on this court. And I think also this is the first opportunity for Che Liang to react through her national counsel and I think she also has a position on this. And I'm available to answer any questions that Your Honors have. I would make one final other observation. The prosecution will have to respond to both appeals. So while each of the defense teams has their separate grounds, the cross, I believe, 227 for Nunchia, and people have made various estimates of what the grounds are for the Q Sampan team, but certainly more than 100. The prosecution will be preparing for both. We think that 11 days would be sufficient for us to do that.
President, the Deputy National Co-Prosecutor, you have the floor. National Deputy Co-Prosecutor, thank you, Mr. President, and good morning, Your Honors. The National Co-Prosecutor concurs with what has been raised by the International Co-Prosecutor, and we wish to resume the hearing of evidence in case 002/02 as soon as possible, as the time allotted for the preparation of the appeal hearing, that is inclusive of the Pyongyang break, as well as the date of the hearing of the SEC's appeal, that is from 16 to 18, is a bit too long. And it is in our opinion that a 1 week preparation for the appeal hearing should be sufficient for this 3-day hearing set forth by the Supreme Court chamber. President, thank you for the observation. And the International Lead Co-Lawyer for Civil Parties, you have the floor.
Je vous remercie.
Thank you, Mr. President. Good morning to all of you. A few short observations for the civil parties so that you can understand that how important it is to balance the rights of all parties when you will rule on the Kyosampan defense's request. We simply wish to remind to the Chamber Rule 109, which governs appeal hearings, in which the defense will have to make a brief presentation of its appeal grounds. So the point will simply be to choose the grounds that are already contained in the final written submissions and to present these orally. The point is not finding new grounds and to develop new strategies, but simply to identify in the written submissions the points that will be necessary to develop orally. The term brief is mentioned 3 times in this Article 109, which governs appeal hearings. The defense, therefore, must present brief oral submissions based on their written submissions that were filed. We will have the possibility of making brief observations in response. And finally, the defense will have the right to present final brief observations. Once again, the point here is to follow a written procedure before the Supreme Court, essentially, and the defense will not have the possibility of developing new grounds, new arguments, or new strategies. And therefore, I am questioning myself about how sound it is to listen, to hear witness 2CW996, who is a witness from case 002, in the appeal of 00201. Apparently, these are 2 different cases, so it will be therefore impossible for the Nguyen Chair defense to use the statement of 2TCW996 to modify, to improve the appeal grounds that were already developed by our colleague. So simply, I would like to raise also the issue of the dates. The co-prosecutor responded to the defense submission on 24 April. We responded on 25 May, and the document was translated into Khmer on the 16th of July, so the defense is perfectly aware of the answers that were provided by us and by the co-prosecutors to their appeal brief, and therefore I'm going to ask you to take these elements into account when you will rule on the Que Sampon defense's request, which has now been supported today by the Nunchea defense. The interest of the civil parties, as we have said since the start, is that case 2-2 can move ahead in the easiest way possible, and this allows me to react now to the last observation by our colleague from the Que Sampon defense. Either we take a break to allow the parties to prepare the appeal hearings, or the chamber will also use this opportunity so that the parties may become aware of the documents that will be disclosed and that will be necessary for the future segments. If that is the case, well, then, of course, we also would like time to be given to the parties so that we can become aware of the documents that may be relevant for the future segments. And for this to happen, it will be useful for all parties to be fully informed of the new disclosures to come that may have an impact on the segment involving the Vietnamese and S-21, so that the chamber may have all of these elements in mind in order to rule on a possible suspension or stay of the proceedings in case 00202, which might have a double objective. First, to give the parties time to prepare the oral hearings before the Supreme Court, and also an opportunity for the parties to become aware of the documents that may be relevant for the future segments in case 00202.
Monsieur le Président,
Mr. President, a few brief observations here.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. President. Let me please take the floor before I give the floor to Council Antaguisse, because I have a question. Council Antaguisse, a little while ago, you did ask for 5 weeks of preparation, and if I remember well, you indicated then that you were considering a bracket of about 10 days for the appeal hearings. But what we know now is that these appeal hearings are scheduled over 3 days. So did you take into account this modification, and how can you justify these 5 weeks of preparation? Because I think that we're facing here a bit of a difference. Well, in order to answer your question, Judge Lavergne, I was speaking here about practical organization. Of course, we are facing an unknown, which is, are we going to be hearing witnesses before the Supreme Court or not? That's an unknown, and I have to take it into consideration when I make my request. But if there are new elements, maybe I will be able to amend my request. But now, for the moment, I'm asking for what I really need, so in order not to be cornered if modifications come into play. So my request, given, well, today, for example, I did not know that there was not going to be any witnesses this week. So I was taking into account the totality of time remaining between the end of the witness testimonies this week and the moment that is liable or the likely schedule before the Supreme Court. Now, to answer the co-prosecutor and also my colleague from the civil parties, I note that in this courtroom, on the side of the defense, when we prepare witnesses, it's always the same lawyers that come to the fore. I'm not speaking about the distinction between Arthur Verken and myself. We, as you know, share the one single position, whether it be to prepare the hearings or to prepare the submissions. We're always speaking about the same lawyers. And when I look at the other side of the room, I see, of course, the lead co-lawyers who always come to the hearings, but it's not always they who examine the witnesses. In the same way that they have that they have other tasks, but they relay each other. Under these conditions, we are not in the same situation in terms of preparation, whether it be for case 002 or for the preparation of the appeal. Now, regarding the fact that we're going to make brief submissions before the Supreme Court, no problem. Brief submissions, choice of arguments, no problem. But if we have to make choices, this means that we have to make determinations, and therefore we have to look at the different written submissions to see what is going to be the most relevant when we're going to assist our clients when we speak before the Supreme Court, and that will take time. So it's true that not everyone is aware of the fact that there is so much work to be done before we come to the courtroom, but given the stakes for Pieux-Saint-Pont and given the impact that the Supreme Court's decision will have on case 00202 as well, you understand that we need to be perfectly prepared, whether it be for the submissions that we're going to make or whether it be to answer the possible questions that the judges may want to raise before us. So whether the civil parties or the co-prosecutors feel that they don't need that much time because they're organized in their own way and because they have the resources, that's their choice. But I'm speaking on behalf of the Pieux-Saint-Pont defense team and on behalf of the defense that we're going to have to provide to our client before the Supreme Court, and we are telling you that the 11 days, such as recommended by the co-prosecutors, are not sufficient. It might be sufficient for the others, so much the better, but I don't want to take that risk. I don't want to just, toe the line and make everyone happy and to explain that I'm going to make the effort necessary to work less because I have less time. No, I'm asking for what I think is the time necessary so that I can defend my client properly and in proper conditions. So I stand by my request despite everyone's observations.
Thank you, Mr. President. A few brief observations. We think it is quite likely that the Supreme Court chamber will indeed summons witnesses. We have presently 13 outstanding witness requests. Considering the investigations that have been done already on behalf of the Supreme Court chamber, we find it highly likely that in the week of 9 or 10 November, so before the submissions, indeed witnesses will be heard. My second point is I indeed concur with my colleague from the Pieux-Saint-Pont team as to the way division of labor is in fact working at this tribunal. I'm here every day by myself together with my national colleague, and I think I've counted once, the prosecution has about 7 different lawyers coming in every day. So it's quite easy to say, well, we have all the time, we have only a week, that is enough for us. It's very easy to say if you have so many counsel sitting in a bench, different counsel. And the last remark, there are not 227 grounds of appeal, but 223 grounds of appeal, but it is indeed our appeal. And if you have filed only one ground of appeal yourself, it's also quite easy to say that a week preparation time should be enough. And so I'd rather had seen that the prosecution would be a little, what's the word? Well, I cannot find the English word presently, should be a little. Sometimes the English is difficult.
Understanding?
Well, thank you, for instance. Yes, thank you. Thank you, Judge Vance.
President, thank you for all the observations made by parties. In particular, what was raised by the defense teams, that is to defer the hearing during the present stage so that they can prepare themselves for the appeal hearing before the Supreme Court chamber. We will take into account all the points raised by the parties. We will deliberate those points, and our senior legal officer will email you and the parties our ruling, as well as the rescheduling of hearing testimonies of witnesses and civil parties. That will be part of the email, and it shall be done before the Pchumban break. And we will adjourn the hearing today, since we cannot do our scheduling, and we will we will reschedule the hearing again after the Pchumban festival. Security personnel, you are instructed to take the two accused back to the detention facility, and we will issue another instruction when the court resumes for them to appear in the courtroom. The court is now adjourned.